with the North American Council on Adoptable Children. Joe Kroll is our executive director, and I am the project coordinator of the Adoption Subsidy Resource Center. And we're going to be talking about kinship care options today for the U.S. Joe will start out the presentation in just a second, but the first piece of housekeeping is how the webinar works. In case you have not been on a webinar hosted by GoToWebinar, this is how it's going to work. You are going to be in mute only. You will be able to ask questions in this little box down here, the questions log, and either Joe or I will be answering questions that we type up. The questions will be going back to you directly unless we think it's a good generic one, in which case we may broadcast it back to everybody. If you are having problems hearing us, you can call in, and if you click on the use telephone here, it will give you the phone number and the PIN to call in on it. It will not be toll-free. If we don't get to all your questions by the end of this session, then we can follow up afterwards. We'll get a report. And also, we were having a little technical difficulties before, and bear with us. We may still have a few as we're doing this. But I think this will be great for all of us. So with that, I'm going to pass this over to Joe in just 1 second here.
Is the slide one?
Yep.
Oh, wait. Oh, you know what? Oh, wait. Oh, you know what? We can echo. Hi, I hope the echo has disappeared here. We're side by side with 2 laptop computers. It appears the echo has disappeared. That's good. Okay. This is about children who are in the care of the public agency. And I wanted to give you kind of an overview that there are 4 different ways that the public agency may interact with a relative caregiver. They may require the relative caregiver or ask the relative caregiver to take care of the child at a guardianship at an initial hearing and do an informal kinship care. And that's the first thing that we'll be talking about, which is a very low level of support. It is a TANF-only grant, which is like a welfare grant, very minimum support. The second one is a family may want to become a licensed foster family. The requirements are slightly different, and for relative caregivers, and I'll go into that in details. A third option that some relatives have taken is to adopt a child whose parental rights have been terminated, and they become the legal, in all ways, the parents of the child, and would be eligible for adoption assistance. Josh will talk about that at length. And then the final one, which is a recent addition to the child welfare system, is legal guardianship with financial assistance and medical support. So those are the 4 different areas that I will be addressing. When a child comes into the care of the child protection system, they may have immediately identified you as a potential relative caregiver, and we know that we have had relatives who have been contacted the same day the child comes into care, told to come down to the court at 10 o'clock in the morning to take guardianship of the child, or the child would put in foster care. Some of you may have experienced that kind of a situation. It's not the best practice in the world, and essentially it would be saying to the relative, you know, you take the kid and we're done. Some states, as part of that, though, will tell the relatives that they're eligible for a child-only TANF grant. The family's not means tested, the child's means tested. So unless the child has a huge bank account, the child's going to be eligible and could receive a very limited grant from the state. Relatives may be offered the opportunity to become a licensed foster parent and receive all the support and services included in that program. There are differences in all 50 states in how that's monitored, but in essence, many relatives have become foster parents, licensed foster parents for their grandchildren. So that was kind of how the county operates. What are your choices? And I think it's really important that you examine carefully and understand what the options are for you. The first question is, do you get legal custody or become a licensed foster parent? And that was the scenario I was talking about earlier, where you were invited down to court at 10 a.m. to take custody of your child. And at that point, you need to say, whoa, okay, if I take that custody, what does that mean? And it may shut the door on future support from the state or county. That's why you have to be very careful not to act too quickly in making that decision. You may choose to just take legal custody, maybe get a TANF grant, but you need to understand that if you do that, it's complicated to get back in the door to receive support from the county. When a relative is considering being a foster parent, one of the things that the county will say to you, or the agency, is there's a series of licensing requirements. And some of the licensing requirements are very specific to safety-related issues. One of the safety-related issues is the ability to exit the home safely in case of an emergency. And so there are factors about door sizes and about window sizes. Some folks with fancy houses have bad windows for people to get out of, and so they're not licensable. So there are a series of safety issues. There are also some non-safety issues that go into licensing requirements, like the number of children per room or the size of bedrooms that can be waived, and the federal government has allowed states to have waivers. But again, as I say, each state is different. I think the advantage to choosing foster care is that you will have ongoing supports. In some states, you can get an emergency license, which really is kind of the safety issues, looking at the residents and making sure that it's up to the safety codes, and you could receive the placement of a relative prior to going through all the licensing steps. And of course, one important licensing step is that the adults in the home are all appropriate. They don't have a criminal record, particularly that relates to violence against people or child abuse, those kinds of criminal records. One of the things that has changed over time, for example, is someone said, well, I stole a car when I was 18. I've got a criminal record for that. Well, those kinds of things can be looked at and said, okay, you're now 40, that's behind you. We won't treat that criminal record as a problem. But you may be delayed in your state based on the licensing requirements and the fact that they don't have an emergency license available for relatives. If you choose foster care, there certainly are a number of benefits available to you. The first one is a monthly stipend. And if you're a licensed foster parent and a relative caregiver, you would be eligible for the stipend equal to any other foster parent. There was a court ruling on on a Minnesota case a number of years ago where they were paying relative caregivers who were licensed foster parents less than foster parents who were not known to the children, and that was ruled illegal. And so now they have to be the same. You would also receive Medicaid for the child, so the medical coverage for your grandson or niece or nephew would be taken care of. There may be other supports. They vary from state to state. Some states provide respite care or daycare, but not all states do. Another level of support would be a clothing allowance. Foster parents, when a child joins their home, will receive a clothing allowance, and they also will receive annual clothing allowances in most states at the beginning of the school year. What are some of the limitations of foster care? If you're a foster parent, the government has a responsibility to monitor the care of the child in your home. That may include monthly worker visits. There also, as the child is going through the process of either reunifying with the parents or moving towards a permanency option with other adults, that the court will have periodic hearings to which you would be attending. If you're a guardian, you've been given custody, and those court hearings would not be there, and you wouldn't have monthly visits from your workers. Foster parents also have training requirements prior to final licensing and ongoing annual training requirements. Typically, those are fulfilled by attending workshops or conferences, and frequently they deal with parenting skills. One of the things that I've learned over time from foster parents who have raised their children and now are becoming relative caregivers is that some of the rules when children were raised 30 years ago have changed, particularly in relationship to discipline, but also some of the norms have changed in relationship to how kids operated in the 70s or 80s versus how they operate now. And going to training classes is actually, I think, a good idea for folks in their 50s or 60s who are starting over in raising children, to be aware of everything that they're dealing with today. There's probably training sessions now for those of us who are older, saying about the warnings about use of internet and tweets and Facebook and what have you that we didn't have when our kids were being raised 30, 40 years ago. Another limitation is on your ability to sign off on things like school changes or medical procedures. In this case, the worker has to do that. You do not have that level of super authority. Good word. Thank you, Josh. In summary, foster care does provide support in terms of benefits and financial support, but you have very limited legal standing, and that's something that you have to weigh. Moving into foster care versus adoption or guardianship. If the birth family is very troubled, relatives may want to prefer some sort of legal protection for the children they're caring for through guardianship or adoption. And when you move to either of those statuses, you have much more authority for making decisions on behalf of your children. One of the things also with foster care is that you really don't have a say in when the child is moved. I mean, literally, you can be told we're coming at 3 o'clock, or we're picking them up at school, and we're moving them back with mom. That is how foster care moves can work. If you're a guardian and you have the legal custody of the child, that custody can only be removed through a court hearing, so that a decision to return the child back to the birth family would have to go back to the courts, and the judge would have to say it's in the best interest of the child. The most significant difference is with termination of parental rights. For an adoption to occur, the birth parents' parental rights would have to be terminated, either voluntarily by the birth parents or involuntarily. There is an exception for customary adoptions with tribes, and if anybody wants to ask a question about that, I can address that as well. But basically, the court has to make a determination that parental rights must be terminated. That could occur, and you could also have a guardianship. I mean, you may be in foster care, and the situation with the birth family is so egregious that the state says these children or child are not going back to the families, and we're going to terminate parental rights while the children are in foster care. You may, for whatever reason, choose to be a guardian over adopting, but there would be then no opportunity for the birth family to come back. More typically, the TPR occurs, though, prior to moving on to adoption. So you can have TPR with guardianship, but it's not required. For adoption, TPR is required. In 2008, the federal government authorized the states to operate a federally supported Title 40 subsidized guardianship program called GAP. They're designed for children and youth who have been in foster care with a relative providing that care for at least 6 months. So in that kind of a scenario, you would have a child brought into foster care by Child Protection. You were identified as the foster parent. You were the foster parent for 6 months, and after that 6-month period, you would then be eligible. That'd be the first step in eligibility for the guardianship assistance program. Also, the child, they would have to determine that reunification with their birth parents and adoption are both ruled out as a permanency option. So reunification, of course, is ruled out because the family has such serious issues that we cannot. There's no hope of the child returning back to the parents. Adoption may have been ruled out because the child is older, or that you, as the relative caregiver, has said that you do not want to choose the permanency option because you do not want to be the one responsible for forcing the issue of terminating parental rights, and therefore you are choosing subsidized guardianship. So those are the conditions that have to be met related to the federal program and the children's status. What does the court do in the cases of the guardian assistance program? The first thing they look at is the placement in your home appropriate, and as a guardian, it appears to be that it will be permanent into their adulthood. Court might also ask the older child for their input in terms of the placement. Is this a placement that is an appropriate placement for you, and one that you want to stay in, and one that you anticipate will be a successful and permanent placement to adulthood? And so the input of the older child is taken into consideration. There's also there's terminology in child welfare about best interest, and the guardianship would be determined to be, of all the choices available to the child, in their best interest, and would grant custody to you, and following that, there would be little or no child welfare agency oversight. The guardian is allowed to make routine decisions without government oversight, such as consent for sleepovers, immunizations, school pictures, travel out of state. One of the things that foster parents talk about, and actually foster youths talk about, is that because of the rules in foster care, they're really sometimes the teenagers are denied the opportunities to do things that other teenagers are allowed to do. And sleepover is one of the classic ones that they mention. It's like, you know, anybody else can say, well, you know, I'm going to be over at Jim's house tonight on a Friday night after the game, and the parents talk to each other, and that's okay with both sides, so it's done. In foster care, you need to have the social worker approve it. In guardianship, you do not. If you go on a vacation out of state, you got to get approval in foster care. You wouldn't have to have that with a guardianship. What are the benefits of GAP? Essentially, the benefits in the Guardian Assistance Program mirror, and Josh will be talking about those, the benefits of adoption assistance. You would be eligible for a monthly subsidy that may be less than, but certainly cannot exceed the foster care rate. That's the way the federal law is written. But in some states, the guardianship rates are lower than the foster care rates. You're eligible for non-reoccurring costs of basically your legal costs related to the guardianship, up to a $2,000 total, and each state chooses what they want to between 0 and 2,000. And if I remember correctly, the lowest state is California, which limits non-reoccurring cost reimbursement to $400. You also would be eligible for Medicaid, and if you were moving to another state, that Medicaid would be transferable as long as you're in the GAP program. Payments would end with the guardianship if it terminated or when the child turns 18. States do have the option of extending the guardianship to 19, 20, or 21, but that's not very broadly seen across the country. Some states have it, but most do not. Okay. One of the important things that came into place when the GAP program was initiated is that a child who comes into the foster care system and is determined to be 4E eligible can transition to legal guardianship or adoption, or transition to legal guardianship and then to adoption, and continue to receive the benefits associated with those programs, and the federal government would reimburse the states for the federal government's share of those costs. And that was an important change in 2008, because at that time some states had guardianship programs that they were paying for with all state money, and now the federal government acknowledged that guardianship programs are important, and so they share in the financial cost of those programs. Currently, 31 states have applied for guardian assistance programs, and I'll put that slide up next. All 50 states and the District of Columbia are required to have adoption assistance programs and do have them. The Guardian's Assistance Program, though, is not required. It's a program that states could opt into. And here are the states. I'll leave that slide up so you can find your states on that list. Some of the states that are not on this list, our home state, Minnesota, for one, should be on the list shortly. They had a guardian. It was called Relative Care Program for guardianship, but it did not meet the federal guidelines, and until this spring they changed the law, so they'll probably be coming to this list in the next 6 months once they apply for it. There are other states that have state guardianship programs but have not yet got into the federal program. Certainly any state with a program that they're fully funding right now, it makes sense for them to move to the federal 4E GAP program. And so this list will probably grow in the near future. There are also 2 tribes, which I did not look up states they're in, but the Port Campbell Skallam tribe and the Confederated Salish, and I won't even try to pronounce these, tribes are eligible for the guardianship program. And now we're going to switch over to Josh. He's answering someone's question right now, so if we can bear with me for a second. He's the adoption subsidy expert, and we're going to switch computers.
All right. So this is Josh now. I deal with adoption subsidy each and every day, all the time. For children to be eligible for adoption subsidy, they must meet the state eligibility requirements, and that varies from state to state. Children who are siblings being adopted together can qualify. In some states, it's 2. Some states, it's to join a sibling group of 2, or to join a sibling. In some states, it's 3 children. I was just in Alabama last week, and it was sibling groups of 3 or more are eligible. I was also in Mississippi last week, and in Mississippi, it's 2 siblings to join a sibling, and they also include fictive siblings. So children who are not actually biologically siblings, but have a relationship as they were siblings. Besides siblings, children of a certain age are going to be eligible. It's as low as 1 in Illinois. So any child over the age of 1 in the state of Illinois is considered special needs. More common is ages 5, 6, 7, 8, but it can be as high as 12 in the state of Kansas. So a healthy 11-year-old without siblings would not be considered special needs in Kansas and would not be eligible. Race. Less and less states include race as a criteria to be eligible. Some states still do, and some tie it to an age. It may be any person of a minority race. It may be children of races that are overrepresented in care. The ages could be as low as 2, but it could be higher. So it depends upon the state. And those have changed over time. Less and less states use race. Disabilities. Children with disabilities typically are considered eligible for adoption assistance. However, the disability has to be documented by a professional. That's very, very clear. It has to be documented by a professional, not just someone thinks or seeing patterns. It needs to be documented, and it needs typically to be, you know, of some consequence, but not always. If it's ADHD or well-managed asthma, neither those things may not qualify. Obviously, things like Down syndrome, cerebral palsy, you know, possibly like oppositional defiant disorder, PTSD, those are more likely to qualify. But disabilities is not just physical, it can also be behavioral or mental. Length and time in care, very few states have this, but a couple of states, if the child's been in care for a certain amount of time, or if the child's been in the care of a foster parent for a certain amount of time and they have an established tie and that family needs the adoption subsidy, that can be sufficient for the child or children to qualify. And the next one is high risk. Not all states have high risk. Illinois, with their age of 1, does not provide this, but many states have high risk. Some of them have pretty stringent documentation requirements, but not all of them do. The high risk typically will come with $0 in subsidy payment, and it may or may not come with Medicaid. But this provides a safety net if problems arise later for the child, if you can get a diagnosis for the subsidy payments to begin. So high risk is sort of the fallback option if the child doesn't qualify for under any other category. Adoption subsidy rates. As with the Guardianship Assistance Program, states do not provide adoption subsidy higher than what the foster care rate is. That's a federal rule, and no state does it. Some states will offer families the maximum rate, and sometimes that's the same as the foster care rate. For example, in Kentucky, a family that is fostering a child, a relative in the foster care system, and they go to adopt, Kentucky typically will offer, same with Rhode Island, many states will offer the same as what the child got in foster care, and families, unless the child's needs are higher and they should qualify for a higher rate, that should be acceptable. In some states, currently in Minnesota, Mississippi, and Washington, the rates are lower than the foster care rates, but families typically don't have to negotiate. They're typically offered the maximum rate allowable by the state, even though it's lower than the foster care rate. And when that happens, that's okay. Families should accept that. They also can advocate for the rates to be increased. That's a separate issue, and one that I'm more than happy to talk with people on an individual basis. Some states will make the family negotiate the adoption subsidy rate, and some of those start at 0. Some of them start at a higher amount, and this can be a very challenging process, especially for relatives who more often than not are not familiar with the system. And when families are negotiating, sometimes the conversation makes the family feel like they're not really committed to the child, that they're fighting over the money when they should just accept the amount offered. And what I say to families is, you're making that commitment to the child and you're going to advocate for them, and part of that is making sure that they have enough resources available to them. So I find that less experienced parents are the ones that are more likely to interpret words that may make them feel like they're fighting over the money. That's okay. And the amount of the subsidy should be based on the ordinary and special needs of the child. Some states are trying to say it's only based on the out-of-pocket expenses that the family incurs, that the ordinary costs are not to be counted. And if you run into that situation, I would suggest contacting me at the office. I'm not going to list the states here, but it's at least a handful. So if you run into that situation, feel free to give me a call. Also, I will be tomorrow, which would be July 24th, doing a webinar or doing a radio interview on that issue with creating a family, and they have a podcast. You can download that too. It'll be an hour long with me and folks from Las Vegas, as well as a moderator. So you can also listen to that to find out more, and that's something that people would be able to access even a long time from now. Interstate issues. The one question I got before, as I was answering before I just started here, is interstate issues. When children are in the foster care system of another state, you have to look at that state's program for eligibility requirements for adoption subsidy, the rates for subsidy and guardianship, subsidized guardianship, and whether or not they have subsidized guardianship. If the child's in Arkansas, I'm making that up, I don't know if they have a guardianship program or not, and let's just say Arkansas doesn't have a guardianship program, then you have subsidized guardianship is not going to be available, and you have to look at adoption assistance if that's something that you need. So that's interstate issues. I run into this issue a lot where children don't formally come into the system. We sort of covered this at the beginning over what are your options. And what I hear a lot from relatives that end up calling me trying to get adoption subsidy is that when CPS got involved, they knew that this relative was involved in the child's life, and they helped them get legal custody of the child. And those TANF child-only grants are not as much support, and there's a lot less cost to the state, just to be honest here. I think that is one of the drivers of that. It may not be the only one, but that's definitely a possible driver of that approach. And these families later on are trying to get adoption assistance, trying to get that child to be legally theirs, especially if the birth parents are still unstable, still causing trouble, and they're looking for some support. Because that child, that TANF child-only grant is going to go away once that family adopts. Because they're no longer going to be a relative care provider, they're going to be an adoptive parent. They're going to be a legal parent. And some of the children in these informal placements, whether CPS was involved or the other very common scenario is the family never wanted the child to go into the foster care system, so they kept the child from going to the foster care system, and they fought to get custody of that child. And some of these children have disabilities. These are going to be significant long-term disabilities, and these children, sometimes they receive SSI based on the child's disability. This is a program that looks at income and assets to see if the child's eligible. Children who receive SSI prior to adoption can be eligible for adoption subsidy. The SSI must be established before finalization, and the subsidy must be applied for after SSI has been determined or established and before finalization. So let me give you a scenario. Let's say I have a cousin or I have a nephew who is born with Down syndrome, and birth parents can't handle the child. They have their own issues, and with the special needs of the child is not safe there. So I intervene. I take the child, a more stable environment. I then apply for SSI for the child. That I'm not. Once that is established, if the Social Security Administration determines the child is eligible for SSI, and I then choose to adopt and the birth parents voluntarily relinquish, I don't have to fight for terminating it involuntarily. I can then turn to my state agency or my county agency and say, I would like to apply for adoption subsidy. And basically, they have to let you. Even if this is done just with attorneys, there are a few states there, including Virginia, Pennsylvania, New York. These are states I've dealt with this recently, who may say, no, the child has to be in state or private agency care. If that is not true when the child receives SSI. So if you run into this situation, feel free to call me because it does happen. It doesn't happen a lot, but it happens. And sometimes the states think that the children are not eligible via this way, especially if it's an independent adoption just through attorneys, and they cannot limit it to just private agency and state adoptions if the child received SSI beforehand. So unfortunately, I usually receive calls from people who adopt children who received SSI before adoption and then try to apply for it afterwards, and that is very difficult and may not even be possible. If you're hearing this and you haven't adopted yet, work through the process. Social Security and adoption. This was on the earlier slide talking about the different benefits. Some adoptive parents who are relatives, especially the grandparents, may be receiving Social Security benefits for themselves based on the money they paid into the system. This is what they call OASDI, or they used to call RSDI. The OA stands for old age, the S stands for survivor, and the D stands for disability. The R instead of the OA was retirement, which is much nicer sounding. So let's say Joe, who is a little older than I am, retires, and he starts collecting Social Security benefits based on the quarters he paid in. If he were to then take a relative into his home and adopt that child, he can get dependent benefits for their child. This is for children who are adopted. It is not for the fostering. It is not for guardianship. And this is not SSI. SSI does not have dependent benefits. Some parents will receive SSI, but the SSI does not have dependent benefits. So that's number one. Number two, sometimes parents' income and assets might be low enough that the child could still get SSI after finalization. If that happens, you know, like the Down syndrome child I was telling you before, if my income and assets were low enough, and that's pretty low, I can't add the subsidy dollars and the SSI together. SSI will be reduced dollar for dollar by the adoption subsidy amount. So let's say in the state of Minnesota, my income's really low, and the child's got Down syndrome, and I can get $700 in SSI, but my adoption subsidy is only $500. What would happen, and we do have pretty low rates here, what would happen is I would get $500 in adoption subsidy, and I would get $200 in SSI. If you ever, so it would be a total of $700. It would be from two different sources. If you're ever given a choice for a child to choose between adoption subsidy or SSI, the choice is always going to be adoption subsidy. And the reason is because adoption subsidy won't change if your income changes or your asset changes. Maybe you get an inheritance and all of a sudden you lose SSI. Well, that's no good. You also don't have to account how you spend that money. That SSI, you will be a representative payee for that child. That means you have to report each year on how that money is spent on the child. You do not have to do that for adoption subsidy. So in terms of the headache over the money you receive, it will be better. No matter what, adoption subsidy, if ever presented with the choice for a child, adoption subsidy versus SSI, the answer is always adoption subsidy. Sometimes children come into, so that's number two. Number three, so down here, states. Sometimes children come into the foster care system because something bad happens to the birth parent. Birth parent might become disabled, can't care for the child. Birth parent may have died. In that case, the child might receive benefits off the birth parent's record if they had contributed enough into the system. It's something the Social Security Administration makes a determination on. So let's say birth mom died and child receives $400 a month in survivor's benefits on her record. The state can, but is not required to, reduce the adoption subsidy based on that other benefit, that survivor's benefit. So if the child gets $400 a month, but they say the proper subsidy is $500, they could say, well, because we know you're getting $400 in survivors, we're only going to give you $100 in subsidy, plus the Medicaid and the non-recurring. But you will not get the, we're going to reduce it by $400. I have no way of making them not do that. In policy, I know Michigan specifically will do that. I can't think of another state I know of currently that specifically says they'll do that reduction, but it's something that any state can do, and I don't know a way to stop. So that's number three. Lastly, some of the families, sometimes relative caregivers, may not have worked enough quarters and might be disabled themselves and may be on SSI. Adoption subsidy payments received on behalf of the child may count against their income when they're calculating if they're eligible for their own SSI. That would be for the adoptive parent. So that's the last one. I am not aware, I don't know if guardianship is treated the same way. There may or may not be guidance on that yet since it's such a new program. So we're at the end here.
You know, how are we going to handle questions? Because
Have we been getting a lot of questions?
not really. Actually, there's one that I did want to address to the entire group, and that relates to if your relative is living in California and you live in Virginia, whose rules apply? And it's the child's residence that would dictate the eligibility for the programs, either the guardianship or the subsidy program, regardless of what state you're in. It's the child's residence. However, if this is a 4E child and you take guardianship from them from California and you live in Virginia, it would be the Virginia Medicaid, though the check would come from the state of California, California's GAP program.
And just to clarify, it's when Joe says residence, he means which state has the child in their legal foster care system. And the other thing I would say about that slide I showed about informal foster care, in this scenario from California to Virginia, if CPS in California contacted this Virginia family and said, we've got this child, they're about to come into care, we're going to help you get legal custody, and the family then goes and gets legal custody, then they're going to apply for that TANF child-only grant in Virginia where they reside because the kid's not in the foster care system in California. If that child had a disability that qualified them for SSI and they became eligible for Title 4E through that SSI, they would actually apply through Virginia in that situation, not California, which is complicated. Basically, what you should take away from that, if it seems real complicated, contact us.
If it seems complicated, it is.
Right.
And one other lengthy questionnaire about dealing with termination of rights of one of the parents, I would suggest you give us a call tomorrow and we'll talk to you about your case.
And one thing I will say, just because I hear this, I don't know what the exact question was because I was talking when it came in, but I have seen, especially in Texas, where people, not always relatives, sometimes the foster parents, where the state says that they're not going to be able to terminate parental rights, so they help them get what they call guardianship, permanent managing conservatorship, PMC, and then they let the family do stuff, and that often does not serve the family well. So, I mean, I think the most important thing, if anything, to take away from this is find out the answers to questions before acting as much as you can. Contact resources like NACAC and other groups, whether national groups or state groups, to know what's going to happen, what the differences are if you make one choice versus another, because it's not always presented really clearly to the families.
I was asked to put the states back up that are eligible, that are participating in the GAP program, and there they are again. This might be illustrative because we've been talking about Virginia and California. The Virginia grandparent who's got the grandchild in California is in better shape of getting support because California has a GAP program.
Right.
But if I'm a grandparent in California and my child's in Virginia, I will not see those benefits as easily because they do not have a GAP program.
I'm going to show you one other thing real quick here. We have on our website information about every state's adoption subsidy program, and it varies from state to state. There's information, I'm just going to go to Virginia. And right here we have the list of who is eligible for special needs for subsidy. We have information about the monthly payments, and then there's the VMAT, which are for higher needs kids. The one other thing I didn't say is the rates will vary. You might, like if you have a sibling group of 2, if one kid is doing pretty well and the other kid's got a lot of issues, the rates are going to be different. They're going to be dependent on the needs of the individual child, whether it's a state that negotiates tough or not. Now we ask a question about subsidized guardianship for every state, and Virginia is planning to implement a program, but they haven't yet. And some states have kinship programs that are not on this list. This list is for the ones that are capturing $40. There are other ones that have, like Florida does have a kinship program, but I believe you still have to live in the state to benefit from it. It's not as good as these programs are going to be because they're going to get reimbursed by federal dollars, and with those dollars come rules that make it a little stronger. So just because your state isn't on this list doesn't mean it doesn't have a program. It just may be a little different. It may not be as consistent as these programs will be. And then I'm going to go to the end. Oops. And it's really any final questions on this whole webinar, just on adoption subsidy. Yeah. So those are our contact information. Any other questions that have come in, Joe?
No, I don't see any other questions on the screen here.
And we got a little late start, but we're wrapping up on time. And you can always follow up with direct questions about your case to us.
If you're calling, we're in the Central Time Zone.
Yes. And I will be heading home after I sign off here.
We all will. Okay.
All right.
Thank you.